Severe Weather Station, News Talk 850 WFTL.
WRMF HD2 Palm Beach.
The following program is paid for by Vastola Legal. The views and opinions expressed in this content do not reflect those of 850 WFTL.
Hey, we know it's early. But what better way to start your day than by getting free legal advice? This is Vastola on the Law with your host, Attorney Jeff Vastola, featuring 30 minutes of free legal advice. Call in now with your questions. 877-850-8585. That's 877-850-8585. Now here's your host, Attorney Jeff Vastola.
Well, good morning, and thank you so much for tuning in to Vastola on the Law. Happy Easter to everybody out there listening. It is Saturday morning at 7:30, and it is time for 30 minutes of free legal advice. I am Jeff Vastola, your host, and I am here to take your phone calls, answer your questions as best I can. So the number for you to dial in to be with me on the radio is 877-850-8585. I'll be giving that number throughout the show. Just as a reminder, that's how you get through to Sharina, who will take your name. She'll send that through to me. We'll put you live on the air with me. If I could answer your question here and now, well, that's great. That's exactly what I'm going to do. If I feel as though I need to spend some more time on the issue, I will research the topic and get back to you the following week with my research, whatever I have found. James called from Boca last week. He asked me a question about a new law passed by the governor of Illinois. And, of course, I had not read that article, but I since have, and I've got some information on that. I want to point out to the listeners again that the Florida Bar, when they approved my radio program going back to 10 to 15 years ago, however long ago it was, they said you're allowed to do the show if you want, with the condition that you can only talk about Florida law. So I'm not going to be talking about the Illinois law because I'm not licensed in Illinois, but I did read the article, found it very interesting, and I want to apply it to Florida and the Florida laws that are already in place. So I'll be talking about that topic that James brought to my attention last week. Thank you again, James, for doing that. And also, I received an email from somebody, and I tried to find the email and could not. I apologize, so I don't have the person's name. But it had to do with where can I smoke? This is a person that is employed, is told that, of course, you're not allowed to smoke inside the place of employment. And her employer apparently has gone on to the extent to say, well, you can't smoke in the parking lot either, so the smokers are being forced to go into the adjacent or the parking lot across the street. And she was recently expelled from that parking lot saying, what are you doing over here? You can't smoke over here either. So the question was, well, where can I smoke? So I've looked into Florida's smoking laws, which now have been amended to include vaping, any kind of electronic cigarette. That's now considered smoking, of course. So I'll be talking about that as well. And, again, I give deference to those people that call into the show because this show is meant to be interactive. It's more interesting to other people when you call in with a question of your own and we can banter back and forth. If you'd like to do that, if you'd like to call into the radio show, the number is 877-850-8585. Now, a little bit of self-promotion. This show is brought to you by my law firm, which is Vastola Legal. We have offices in Palm Beach Gardens and Stewart, and we represent clients throughout the state. We handle Monday through Friday personal injury and wrongful death claims. And I would really encourage everybody this week to please go to my website. We've finally launched a new website. I know I've been talking about it for a very long time, but we finally launched it. The new site is live. If you go to www.vastolalegal.com, you can see it. Vastola, V as in Victor, A-S-T-O-L-A. Go to vastolalegal.com and check out the new website. There is some content that we've taken from the old site that probably needs to be refreshed and some deleted, but it's an ongoing process. But I'm really proud of the new site. I think the web developers, we have a team that I've been working with. They've done a great job. So kudos to them. I want to give a shout out to Florida Weekly and their digital partner, their web partner, for doing the website. Thank you so much. And I really appreciate your work. So, if you'd like to reach me to talk about a case that you think you have or an issue, the number to reach me personally, 24/7. This is not the number to call into the show and ask me a question on the show. The number to call me personally when the show is over, at night, on the weekend, 833-VASTOLA. That's 833-827-8652. That number is always forwarded to my cell phone, no matter what time of day it is. And if I don't answer, you can leave me a voicemail message and I will call you back. I like to try to be as available as I can be. You'll see from the website, if you go to visit it, that you can contact me anytime. Every single page on the website has a way for you to contact me, but it's pretty obvious from the home page that you can send me a quick little email. And of course, this same phone number is there on the site. If you ever have any questions of a legal issue, of a legal nature, feel free to call me. 833-VASTOLA. That's V as in Victor, ASTOLA. So, all right, enough self-promotion. Thank you so much for tuning in today. I want to talk first about the issue that James brought to my attention last week. This is it wasn't so much a question as it was a comment to say, did you see the new law passed by the Illinois governor? I did not. It's Executive Order 2020-19, and there is a brief article. The one that James mentioned is the one that I found. It's contained on the National Law Review, and it looks to be written by Robert Neiman. I'll give props out to the author here on this article. Robert Neiman wrote about this, and essentially he boils it down to this. It says, our best interpretation of the act and the intent of the executive order is that healthcare providers and employees have immunity from civil liability in treating COVID-19 patients and residents, and, this is where it gets interesting, and from such liability if other patients or residents contract COVID-19, presumably from that person, as long as the healthcare facility and its employees were not grossly negligent or did not engage in willful misconduct. So that's a pretty good summation of the article and the intent of the new law. So I want to point out a few things. First of all, in Florida, in order to ever have any kind of a claim based on negligence or malpractice, any kind of negligent or professional malpractice, you always must be able to prove, and you have a burden of proof if you're the plaintiff, you must be able to prove the causation link. Okay, a negligence claim is always going to consist of the liability aspect of the claim, meaning who was at fault. The next piece that you have to prove is causation, meaning did this person's negligence or this person's mistake cause me any harm? And then the last section is damages. That's what you have to prove. How has this affected me, either economically or non-economically, in the form of pain and suffering, mental anguish, that type of thing. To suggest that you would be able to prove that a specific person passed on COVID-19 to you, in my opinion, is going to be next to impossible. This disease, from what I understand, and I have a layperson's understanding of COVID-19, is so incredibly contagious, and the germs, the cooties, they linger for such a long time that essentially if you contract the disease, you could have gotten it anywhere. And there's just no way to know, where did you get it? Now, in theory, I suppose the only way you'd be able to prove that you contracted COVID-19 from a specific person would be if you had been living in a bubble for the past 6 months, had no visitors, had a clean bill of health, and then you had one person come see you that you had interaction with, and then all of a sudden you've contracted the disease because they passed it through your bubble. I mean, I hate to sound silly, but I don't see how in the world a plaintiff would be able to prove that a specific person or a specific facility caused them to have COVID-19, because it can hibernate for such a long time. Now, those are just my thoughts. I don't ever want to give anybody legal advice that's not necessarily asking for it. But this article, that's what almost immediately jumped out at me, is that it's not unnecessary. I could see why the governor did it. I can see why it would prevent a lot of lawsuits from being filed, and perhaps, that's its purpose, because you could have lawsuits that get filed, but then the plaintiff loses the case because they can't meet their burden. But what I wanted to point out with regard to Florida law is that not only would it be a very, very, very high threshold to be able to meet the causation burden in a COVID-19 case, but Florida already has these laws on the books. And that's what's really interesting about this, is that our Florida governor doesn't have to pass these laws because they're already there. For example, I wanted to talk about the one that's probably most on point is Florida Statute 768.1345. Okay, this is a very, very brief statute, one of the shortest statutes that you'll find on the books. It's entitled Professional Malpractice Immunity. It says no person shall have a claim for professional malpractice against a licensed professional who provides services for which no compensation is sought or received to such person during the period of a declared emergency, if the professional services arose out of the emergency and if the professional acted as an ordinary, reasonably prudent member of the profession would act under the same or similar circumstances. So Governor DeSantis and President Trump have declared a state of emergency. So this statute has since been enacted, so to speak. And it contains very similar language to what the governor of Illinois enacted, in that as long as this person is acting within reasonably prudent, if their professional acted as an ordinary, reasonably prudent member of the profession would have acted. And what that does is it allows a sliver of cases to exist where somebody did something intentionally or wantonly. And it's funny because in law school, when we law students are learning torts, which is a word for any kind of a negligent act. It can also include a product failure, product defect, that's a tort. Any kind of an incident causing injury to a person where they may have a civil claim for damages is a tort. And when we're learning torts in law school, typically somebody will read the word wanton as wonton. And all of a sudden you get into this funny discussion of, what does a wonton have to do with torts? No, it's wanton. Wanton is an adjective, and it means without care or concern of another person's well-being. So if you act intentionally or with wanton or reckless disregard for somebody else, then even these statutes that exist in a time of emergency are not going to protect you. So if you happen to be in the field, if you're a medical care provider, just understand that absolutely positively you should be protected, as long as you don't have an ulterior motive. If you don't have some other hidden agenda where a patient walks in the door that you've hated for the last 10 years and now's your chance to get back at this person, don't do it, because for obvious reasons don't do it, but these statutes are not going to protect you. Okay, so the other one that I wanted to talk about was the Good Samaritan Act. Okay, the one that I just read to you, the prior one, 768.1345, is professional malpractice immunity. Well, good news is Florida Statute 768.13, which is entitled Good Samaritan Act, immunity from civil liability, this can apply to everybody. This applies to everybody. And I had talked about this statute maybe 6 months ago, could be longer, when I was at a house party and I was talking to a friend, and he said, well, I've got this story, and he told me about a guy that lifted up a woman who had fallen off the hot asphalt, and she later sued him because she had suffered some kind of a neck or back issue. And I was asking my friend at the party, I'm like, well, whatever happened with the lawsuit? And he didn't really have a lot of detail, but he knew his friend was really upset because he was trying to help, and he ended up getting sued. And my comment to him at the party was, well, I'd like to know more. I'd like to, have your friend call me and tell me what happened, because perhaps the case wasn't defended appropriately. These statutes are there as a defense to a case. And the reason why I bring up that past discussion and that past incident was because that's precisely why this Good Samaritan Act is in place. For people, they don't have to be a professional, meaning a doctor or a nurse or some other form of healthcare provider that's professionally licensed. It could be you and me, that as a Good Samaritan, you're just there to provide some assistance. Well, you've heard the story, the Good Samaritan provides some kind of assistance, and because of a neck or back problem, there's allegations that now the person's paralyzed or whatever. And this statute can help you. It's really there as a means to give an affirmative defense to a case like that, so that even if one does get filed against you, you can defend it successfully and perhaps even get it thrown out relatively quickly. My friend, his commentary to me was that the person he knows that was sued was upset, and I was led to believe ultimately ended up paying money. And that may very well be because of the way the case was defended. And somebody rendering legal assistance that just perhaps didn't know about the statute, which I find hard to believe, but I guess that could happen. So understand, Florida law includes a lot of these provisions. Florida Statute 768, you can find these if you want. Good Samaritan Act is 768.13. The Good Samaritan Volunteer Firefighters Assistance Act is 768.1315. So it didn't say just firefighters, it says volunteer firefighters. 768.1325, the Cardiac Arrest Survival Act, immunity from civil liability. The 768.1335, Emergency Medical Dispatch Act. Let me see, 768.135, Volunteer Team Physicians. 768.1355, Florida Volunteer Protection Act. There's all kinds of protections in place for people that volunteer and those that don't volunteer who are in the first responder type of fields, or even in the medical field, as you've seen. So if anybody has any questions in follow-up to what I've talked about so far, please call me. The radio station number is 877-850-8585. And I'd love for you to call into the show. Give me some interaction. Give me a topic that I can use for next week's show. I love it when I am asked a question that I cannot answer because it forces me to do the research, and I love learning new things. I tell my kids all the time, especially when we're driving to school and they're complaining about having to go to school, learning is cool. I love learning new stuff. I wasn't always like that, and I'm very honest with my kids. When I was younger, for some reason, going to school and learning new things was not cool. It was not fun. It's not what I wanted to do. I was a typical boy. I wanted to be outside running and playing and riding my bike. But as I got older, I realized that doing research and learning new things, I really enjoy it. So I'm not just saying that. I genuinely want people to call into the show and ask me questions that I do not know the answer to. If I know the answer, that's easy. And we can have a conversation if you want. But I enjoy the questions I don't know the answer to. Let me see. Where can I smoke? Let me cover this before my show is over. And then I wanted to talk to you guys. I like to do a case law update every once in a while. And I have a new case that I want to talk to you guys about if I have the time. So let me pull up. It's funny I've been told I should do a Facebook Live. And every time somebody suggests that I do Facebook Live with my show, I say, well, I don't think you want to see what I look like 7:30 on a Saturday morning, because I'll just be honest, I haven't showered, I haven't done anything. But it might get to the point that I'm doing Facebook Live here very soon, and you'll see my setup. It's pretty funny. I've got computer screens up all over the place. All right. Where can I smoke in Florida? If you're interested in learning more about Florida's smoking regulations, you can go to Florida Statute 386.202. That's the Florida statute that governs where you can smoke and everything else. It's the Chapter 386 is entitled Particular Conditions Affecting Public Health, and Section 386.01 through 051 is entitled Sanitary Nuisances. And this is Part 2, Section 386-201 through .2125 is Florida's Indoor Clean Air Act. But essentially, it's a relatively short statute which tells you what the nuisances are and where you can smoke. The person that contacted me to say, well, I'm in the parking lot and they're telling me that I can't smoke in the parking lot. Unless this parking lot is very close to a school, and I believe the statute on that particular issue says within 1,000 feet of a school you can't smoke. There's no restriction to smoking in a parking lot, especially if you're in your own car. Now, that would be a parking lot that you're entitled to be in. For example, your employer's parking lot. When you go across the street, if it's private property, to smoke in somebody else's property, even if it's on their parking lot, arguably, theoretically, you might be deemed a trespasser depending on why you're there. And so I don't want to say, well, sure, you can go into any parking lot you want and smoke. There's no restriction in the statute as to smoking in a parking lot, at least one that I've seen. But keep in mind, if you go to a private parking lot somewhere and you try smoking and somebody says, in this particular case, a security guard came up in a golf cart and said, I'm sorry, after inquiring, who are you, why are you here, and learning that you're not there for a legitimate business purpose, they can say, well, please leave. And then if you don't, then you might actually get the cops to come see you. All right, I've got somebody on the phone. I've got Dan from Jupiter. Thank you, Sharina. Let's put Dan on line one. Good morning, Dan.
Hi, good morning.
How are you?
I got a question about the Waxahachie River District, and one of the things that they're doing is forcing people to give up their septic system and convert to the public sewer. And if you're downhill from the sewers, you have to purchase a lift station. But my question is, they make you pump out your septic, they make you punch a hole in the bottom of it, and then they make you backfill it, and you have to pay for all this. I knew one lady, her panel, her electric panel, wouldn't support the pump, so they made her heavy up. So she actually had to sell her house because she couldn't afford it. But my question is about the Fifth Amendment taking clause, where no private property shall be taken for public use without just compensation. And I was wondering if that applied or not, because they're making you backfill your septic.
Well, let me jump in real quick, Dan.
They're basically taking
let me jump in real quick because I'm going to run out of time if I don't jump in here. Dan, I need to jump in real quick so I don't run out of time and address your question real quick. I'm not familiar with this. I'm not aware that this has been happening. But as I was reviewing my Florida Law Weekly publication for this week's show, I came across a takings case that I was potentially going to talk about. It's out of Manatee County, and it's the case of State of Florida versus Mandarin Development Incorporated. And for those of you that are not aware, what Dan is referring to is a law in Florida that says that the government basically cannot come in and just take your stuff. If they're going to take property from you, they have to go through the proper channels, and they also have to pay just compensation if they're going to do that. Dan, I appreciate the heads up on what's going on, and I've heard what you were saying, but I do have to do some research into it to get a little bit better idea as to whether this would truly be a takings issue or something else. But let me give you just another minute or two to fill in anything else that you might want me to look into, and I'll research it, and we'll talk more about it next week. So back to you, Dan.
Yeah, it's the Waxahachie River District. Am I still here?
Yes. Go ahead, Dan.
Yeah, it's the Waxahachie River District. They're off of Jupiter Park Road, and they're forcing everyone to do it. But the thing is your septic system, it treats, by the time anything reaches the water, it's going through, 20, 30, 40 feet of sand before it even makes it to any water. And I'm sit outside the back and watch all these people playing the lagoon, and birds and everybody are doing all kinds of stuff in the water. And meanwhile, they're making you pay, I think it was like $5,000. It was free to go to the bathroom. Then for the first year, it was $2.50 a day, and then 25 cents a day for the next 10 years because they put it on your taxes.
Wow.
All
right, Dan, I appreciate the call. I have to interject again because Sharina's going to start talking in my ear that I'm out of time because I actually don't get to go until 8 o'clock. I only get to go until about 7:58. But, Dan, please tune in next week. Call in next week, and we'll have a better discussion about what this is all about, okay? I appreciate the call.
Okay. All right.
For those of you that listen to the show, thank you, Dan. Take care. If you'd like to talk to me off the air, if you have a question or if you have a case that you'd like to talk to me about, please dial 833-VASTOLA. That's 833-827-8652. And remember, when you're faced with a situation and you're not sure what to do, always do the right thing. So, happy Easter to everybody again. Thank you so much for listening. Sharina, thank you so much. I appreciate all you do. And everybody have a great week. Talk to you next Saturday morning at 7:30 for some more free legal advice.
You've been listening to Vastola on the Law with attorney Jeff Vastola. Turn in next week for more legal advice and answers to your specific questions. You can call Jeff on his cell phone after the show by dialing 833-VASTOLA. That's 833-827-8652.